Welcome to Birdsey. In this video, we'll work through exam-style questions, show you what the exam is really testing, and give you clear takeaways to get you ready for exam day. Let's get started!
Let's jump right into property ownership and land use controls. Which form of property ownership allows two or more people to own property with the right of survivorship? Is it A, tenancy in common, B, joint tenancy, C, sole ownership, or D, community property? The correct answer is B, joint tenancy. Joint tenancy allows two or more people to own property together with the right of survivorship, meaning if one owner dies, their interest automatically passes to the surviving owner or owners. Which statement about tenancy in common is not true? Is it A, each owner may sell their share independently? B, ownership shares can be unequal? C, there is a right of survivorship between co-owners? Or D, each owner can will their interest to heirs? The correct answer is C, there is a right of survivorship between co-owners. Why this is tricky? The question asks for the false statement. Tenants in common can sell or will their interest, and shares can be unequal, but there is no right of survivorship in tenancy in common. All of the following are forms of concurrent ownership except which one? B, tenancy in common, C, community property, or D, sole ownership. The correct answer is D, sole ownership.
Why this can be tricky.
The question uses except, so you must identify the one that is not a concurrent ownership form. Several options sound similar, but sole ownership is not concurrent. Maria and Lee, who are not married, purchase a home together and want their shares to pass to their heirs if one dies. Which form of ownership should they choose? Is it A, tenancy in common, B, joint tenancy, C, community property, or D, tenancy by the entirety? The correct answer is A, tenancy in common. Tenancy in common allows co-owners to pass their shares to heirs rather than the surviving owner, making it the best choice for Maria and Lee's goals.
A married couple in a community property state buys a house together.
What happens to the property if one spouse dies without a will? Is it A, the property is automatically sold? B, the deceased spouse's share goes to their children only? C, the surviving spouse usually receives the deceased spouse's share? Or D, the property is transferred to the state? The correct answer is C, the surviving spouse usually receives the deceased spouse's share. In community property states, the surviving spouse typically receives the deceased spouse's share of community property, even if there is no will, unless otherwise specified by state law.
How'd you do on the first 5 questions? Go ahead and subscribe to Birdsey now and turn your progress into exam day confidence. Ready to jump back in? Let's go!
Alex and Jordan, who are not married, purchase a vacation property together and want each of their shares to pass to their chosen heirs if one of them dies. Which form of ownership best meets their goal? Is it A, joint tenancy, B, tenancy by the entirety, C, tenancy in common, or D, community property? The correct answer is C, tenancy in common. In tenancy in common, each owner's share passes to their heirs, not the surviving co-owner, making it the best choice for Alex and Jordan's wishes. Joint tenancy and tenancy in common distinctions. Which of the following is a key feature of joint tenancy in property ownership? Is it A, right of survivorship, B, ownership can be unequal, C, owners can will their share to heirs, or D, ownership is always for business purposes? The correct answer is A, right of survivorship. Joint tenancy includes the right of survivorship, meaning when one owner dies, their interest automatically passes to the surviving joint tenants. Which statement about tenancy in common is not correct? Is it A, each owner may sell their share independently? B, there is no right of survivorship? C, all owners must have equal shares? Or D, each owner can will their interest to heirs? The correct answer is C, all owners must have equal shares. Why this is tricky? The distractors are all true except the correct answer. Tenancy in common does not require equal shares. Owners may hold unequal interests. Maria and John own a property as joint tenants, and when Maria dies, what happens to her share? Is it A, it goes to Maria's heirs? B, it passes to John automatically? C, it is divided among all family members? Or D, it is sold and proceeds are split? The correct answer is B, it passes to John automatically. Upon Maria's death, her share automatically transfers to John due to the right of survivorship and joint tenancy.
If you want more than just rapid-fire questions, head over to birdsey.ai. You can take unlimited practice exams and get instant help from your personal AI study partner. It's like having a tutor 24/7. Try it free. You'll find a link in the description.
If 3 people hold title as joint tenants and one sells their interest, what is the result for the remaining owners? Is it A, all become tenants in common? B, the property must be partitioned? Or D, the remaining 2 keep joint tenancy between themselves? The correct answer is D, the remaining 2 keep joint tenancy between themselves. Why this can be tricky? The sale severs joint tenancy for the seller, but the remaining 2 retain joint tenancy between themselves. 2 siblings inherit a property as tenants in common, and one wants to sell their share while the other does not. What can the selling sibling do? Is it A, sell their share independently? B, force the other to sell the entire property? C, wait until both agree to sell? Or D, convert the ownership to joint tenancy? The correct answer is A, sell their share independently. A tenant in common may sell or transfer their share without the other owner's consent. Community property terminology and rights. Which of the following best describes community property in states that recognize this form of ownership? Is it A, property acquired by either spouse during marriage except by gift or inheritance? B, property owned by one spouse before marriage? C, property held in joint tenancy with right of survivorship? Or D, property acquired by either spouse at any time regardless of marital status? The correct answer is A, property acquired by either spouse during marriage except by gift or inheritance. Community property is property acquired by a married couple during their marriage, except for gifts or inheritances to one spouse. Both spouses have equal ownership rights to community property. Which statement about separate property in a community property state is not true? Is it A, separate property includes assets acquired before marriage? B, gifts to one spouse during marriage are considered separate property? All separate property is divided equally between spouses upon divorce? Or D, separate property can become community property if commingled with marital assets? The correct answer is C. All separate property is divided equally between spouses upon divorce. Why this is tricky? The question asks for the false statement. Separate property is not subject to division as community property upon divorce, but income from separate property may become community property in some cases. Maria and Luis A married couple in a community property state buy a home together using only funds Maria inherited from her aunt. Who has ownership rights to the home under community property law? Is it A, both Maria and Louis equally as community property? B, Maria only as her separate property? C, Louis only as the spouse not receiving the inheritance? Or D, the state until both spouses agree on ownership? The correct answer is B, Maria only as her separate property. Because Maria used inherited funds, the home is considered her separate property, even though it was purchased during marriage, unless the funds were commingled with community assets. Life estates and future interests recognition. Which term describes the interest held by a person who will receive ownership of property after the death of a life tenant? Is it A, remainder interest, B, leasehold interest, C, fee simple absolute, or D, easement? The correct answer is A, remainder interest. A remainder interest is the future interest held by someone who will receive title to the property after the life estate ends. This is a key concept in life estates and future interests. Which of the following is not typically true about a life estate? Is it A, the life tenant may sell their interest, B, the life tenant must maintain the property, C, the life tenant's heirs automatically inherit the property, or D, the life estate ends when the life tenant dies? The correct answer is C, the life tenant's heirs automatically inherit the property. Why this may be tricky. Some options sound plausible, but only the statement about the life tenant passing ownership to heirs is false. Life estates end at the life tenant's death and do not pass to heirs. Maria grants her home to her brother Tom for life, and upon Tom's death, the property will go to her niece Lisa. What interest does Lisa hold during Tom's lifetime? Is it A, life estate, B, reversionary interest, C, leasehold interest, or D, remainder interest? The correct answer is D, remainder interest. Lisa holds a remainder interest because she will receive the property after Tom's life estate ends, but she has no present rights until then. Encumbrances and liens terminology. Which of the following best describes an easement? Is it A, a right to use another's land for a specific purpose, B, a claim for unpaid property taxes, C, a restriction on building height, or D, a transfer of full ownership? The correct answer is A, a right to use another's land for a specific purpose. An easement is a non-possessory right to use another person's land for a specific purpose, such as access or utilities, without owning the land itself. Which statement about liens is not accurate? Is it A, a lien is a claim against property for a debt, B, liens can be voluntary or involuntary, C, all liens are created by agreement between parties, or D, a mortgage is a type of lien? The correct answer is C, all liens are created by agreement between parties. Why this is tricky. The question asks for the inaccurate statement. Only voluntary liens are created by agreement, while others, like tax liens, are imposed by law. Maria sells her property to Tom, but a recorded judgment against Maria remains unpaid. Who is responsible for the judgment lien after the sale? Is it A, Maria remains solely responsible, B, Tom may be responsible if the lien is not satisfied before transfer, C, the lien is automatically removed upon sale, or D, the lender pays the judgment lien? The correct answer is B, Tom may be responsible if the lien is not satisfied before transfer. A judgment lien attaches to the property and typically remains until paid. So Tom, as the new owner, may be responsible unless the lien is cleared before transfer. Which of the following is always considered an encumbrance on real property? Is it A, a zoning ordinance, B, a building code requirement, C, a property tax assessment, or D, an easement? The correct answer is D, an easement. Why this can be tricky. Not all restrictions or claims are encumbrances, but an easement always limits the owner's use and is considered an encumbrance. A developer places a deed restriction prohibiting commercial use on a subdivision. What type of encumbrance is this? Is it A, a lien, B, an easement, C, a restrictive covenant, or D, a license? The correct answer is C, a restrictive covenant. A deed restriction is a private limitation on land use, classified as a restrictive covenant, which is a type of encumbrance affecting property rights. Easements and licenses definitions. Which of the following best describes an easement appurtenant? Is it A, a right that benefits a specific parcel of land and passes with title, B, a temporary right to use another's land for a specific event, C, a right that benefits the public at large, or D, a revocable privilege to enter another's land? The correct answer is A, a right that benefits a specific parcel of land and passes with title. An easement appurtenant is a right attached to a parcel of land that allows the owner to use a neighboring property for a specific purpose, such as access. It benefits the dominant estate and runs with the land. Which statement about licenses in real estate is not accurate? Is it A, a license is a personal privilege to use land, B, a license can be revoked by the landowner at any time, C, a license automatically transfers to new owners when the property is sold, or D, a license does not create an interest in the land? The correct answer is C, a license automatically transfers to new owners when the property is sold. Why this is tricky. The distractors closely resemble easement characteristics. Licenses are personal, revocable privileges that do not transfer with the land and can be terminated at any time by the grantor. All of the following are true about easements in gross, except: is it A, they benefit a person or company rather than a parcel of land, B, they automatically transfer to new owners of the dominant estate, C, they can be created for utility companies, or D, they do not require a dominant tenement? The correct answer is B, they automatically transfer to new owners of the dominant estate. Why this may be tricky. The options mix up characteristics of easements in gross and appurtenant. Easements in gross benefit a person or entity, not a parcel of land, and do not transfer with land ownership. Maria grants her neighbor Tom written permission to park in her driveway for 1 month, but later sells her home to someone else. What happens to Tom's right to park? Is it A, Tom's right becomes a permanent easement, B, Tom's right continues until the month ends regardless of ownership change, C, Tom's right ends when the property is sold to a new owner, or D, Tom's right converts to an easement in gross? The correct answer is C, Tom's right ends when the property is sold to a new owner. Tom's right to park is a license, not an easement. Licenses are personal, revocable, and do not transfer with the property when it is sold to a new owner.
Have you noticed the code in the bottom corner? The next time you're stumped, take that code to birdsey.ai. You'll get immediate help, complimentary study sessions, and access to hundreds of additional questions. It's the best tool to help you pass with confidence.
Deed types and ownership transfer terms. Which type of deed provides the greatest protection to the grantee in a real estate transaction? Is it A, general warranty deed, B. Special warranty deed. C. Quitclaim deed. Or D. Bargain and sale deed. The correct answer is A. General warranty deed. A general warranty deed offers the most comprehensive protection to the grantee because it guarantees the title against all claims, both before and during the grantor's ownership. Other deed types offer more limited warranties or none at all. Which of the following statements about a quitclaim deed is not accurate? Is it A. A quitclaim deed transfers any interest the grantor may have? B. A quitclaim deed provides no warranties to the grantee? C. A quitclaim deed guarantees the grantor has good title? Or D. A quitclaim deed is often used to clear up title defects? The correct answer is C. A quitclaim deed guarantees the grantor has good title. Why this may be tricky. The quitclaim deed does not guarantee that the grantor owns the property or that the title is clear. It simply transfers any interest the grantor may have, if any, without warranties. If a deed is signed but not delivered to the grantee, which of the following is true regarding the transfer of ownership? Is it A. Ownership automatically transfers upon signing? B. The deed is valid as long as it is notarized? C. Recording the deed is required for transfer to occur? Or D. No transfer occurs until the deed is delivered and accepted? The correct answer is D. No transfer occurs until the deed is delivered and accepted. Why this can be tricky. Delivery is a crucial step in transferring title. Even if a deed is properly signed, ownership does not transfer until the deed is delivered and accepted by the grantee. Maria sells her home to David and gives him a special warranty deed. What type of title protection does David receive in this transaction? Is it A. Protection against all title defects, regardless of when they occurred? B. Protection against title defects that occurred during Maria's ownership only? No protection against any title defects? Or D. Protection only if the deed is recorded? The correct answer is B. Protection against title defects that occurred during Maria's ownership only. A special warranty deed protects David only against title defects that arose during Maria's period of ownership, not before. It does not guarantee against claims from previous owners or earlier title issues. Agency, relationships, and contracts. Which term describes a real estate agent who represents only the buyer in a transaction? Is it A. Buyer's agent? B. Dual agent? C. Subagent? Or D. Transaction broker? The correct answer is A. Buyer's agent. A buyer's agent is a real estate professional who exclusively represents the interests of the buyer in a transaction, as defined by most state real estate commissions and the National Association of Realtors. Which of the following is not a fiduciary duty owed by an agent to their principal? Is it A. Loyalty? B. Disclosure? C. Compensation? Or D. Obedience? The correct answer is C. Compensation. Why this is tricky. Loyalty, obedience, and disclosure are classic fiduciary duties. Compensation is not a fiduciary duty. It is a contractual term, not an obligation of trust or care owed to the principal. Maria, a licensed real estate agent, is helping both the buyer and the seller in the same transaction with written consent from both parties. What type of agency relationship does this describe? Is it A. Single agency? B. Dual agency? C. Designated agency? Or D. Implied agency? The correct answer is B. Dual agency. This scenario describes dual agency, where one agent represents both parties in the same transaction with informed written consent, as required by most state laws and real estate boards. A subagent in a real estate transaction owes fiduciary duties to which party? Is it A, the buyer only, B, the seller only, C, both buyer and seller equally, or D, no party in the transaction? The correct answer is B, the seller only. Why this can be tricky? Although a subagent may work with a buyer, their fiduciary duties are owed to the seller since they are acting on behalf of the listing broker, not the buyer. If a brokerage firm assigns one agent to represent the seller and another to represent the buyer in the same transaction, what is this arrangement called? Is it A, dual agency, B, transaction brokerage, C, subagency, or D, designated agency? The correct answer is D, designated agency. This is called designated agency, where different agents in the same firm represent different parties, as recognized by many state real estate authorities. Fiduciary duties definitions and identification. Which fiduciary duty requires an agent to keep a client's confidential information private, even after the agency relationship ends? Is it A, obedience, B, loyalty, C, confidentiality, or D, disclosure? The correct answer is C, confidentiality. The duty of confidentiality obligates an agent to protect a client's private information during and after the agency relationship. This is a core fiduciary duty defined by most real estate licensing authorities and is essential to maintaining client trust. Which of the following is not considered a fiduciary duty owed by a real estate agent to their client? Is it A, loyalty, B, compensation, C, accounting, or D, reasonable care and skill? The correct answer is B, compensation. Why this is tricky? All options except compensation are classic fiduciary duties. Compensation is not a duty owed by the agent to the client. It is a term of the agency agreement, not a fiduciary responsibility. An agent must always disclose every detail about a property to a client, even if it is not material to the transaction. Is it A, true, B, only if the client asks for the information, only if the agent believes it affects the price, or D, false? The correct answer is D, false. Why this can be tricky? The duty of disclosure requires agents to share all material facts, not every detail. Non-material information does not have to be disclosed, so the statement is false. Maria, a real estate agent, receives an offer on her client's property, but knows of another potential buyer who may offer more. What fiduciary duty requires Maria to inform her client about this possibility? Is it A, accounting, B, disclosure, C, obedience, or D, confidentiality? The correct answer is B, disclosure. The duty of disclosure requires Maria to inform her client of any information that could affect the client's decision, including the existence of other potential buyers who may offer more. A seller's agent accidentally tells a buyer confidential information about the seller's motivation to move. Which fiduciary duty has the agent breached in this situation? Is it A, loyalty, B, disclosure, C, confidentiality, or D, accounting? The correct answer is C, confidentiality. The agent has breached the duty of confidentiality by revealing private information about the seller's motivations, which could harm the seller's negotiating position. Listing agreement types and terms. Which type of listing agreement allows a seller to employ multiple brokers but only pay commission to the broker who brings a ready, willing, and able buyer? B, Exclusive right to sell listing. C. Exclusive agency listing. Or D. Net listing. The correct answer is A. Open listing. An open listing allows the seller to list the property with multiple brokers and only pay commission to the one who successfully procures a buyer. This is different from exclusive agreements, which limit the seller to one broker. Which of the following is not a required element of a valid exclusive right to sell listing agreement? Is it A. Definite expiration date? B. Broker's personal guarantee of sale? C. Description of the property? Or D. Specified commission terms? The correct answer is B. Broker's personal guarantee of sale. Why this may be tricky. All options seem important, but only some are legally required. The broker's personal guarantee of sale is not required for validity. The other elements are standard requirements for enforceable listing agreements. Maria signs an exclusive agency listing with broker Lee, but later finds a buyer herself without Lee's help. Who is entitled to the commission in this situation? Is it A. Broker Lee receives full commission? B. Both Maria and broker Lee split the commission? C. Maria owes no commission to broker Lee? Or D. Broker Lee receives a reduced commission? The correct answer is C. Maria owes no commission to broker Lee. In an exclusive agency listing, the broker earns a commission only if they or another broker procure the buyer. If the seller finds the buyer independently, no commission is owed to the broker. A seller enters into an exclusive right to sell listing with broker Kim, but later sells the property to a friend without Kim's involvement. Is broker Kim entitled to a commission? Is it A. No, because the broker did not find the buyer? B. No, unless the broker participated in negotiations? C. Yes, but only if the friend was previously introduced by the broker? Or D. Yes, broker Kim is entitled to a commission. The correct answer is D. Yes, broker Kim is entitled to a commission. With an exclusive right to sell listing, the broker is owed commission regardless of who finds the buyer, even if the seller finds the buyer independently. Offer and acceptance terminology. Which term describes the party who makes an offer in a real estate transaction? Is it A. Offerer, B. C. Agent, or D. Principal? The correct answer is A. Offerer. The party who makes an offer in a real estate transaction is called the offeror. The offeror initiates the contract process by presenting terms to the offeree, who can then accept, reject, or counter the offer. Which of the following statements about acceptance of an offer is always true? Is it A. Acceptance is valid even if the offeror is unaware of it? B. Acceptance must be communicated to the offeror to be valid? C. Acceptance can only be made in writing? Or D. Acceptance is valid only if made within 24 hours? The correct answer is B. Acceptance must be communicated to the offerer to be valid. Why this is tricky. The word always can mislead. Acceptance must be communicated to the offerer to be valid, but not all methods, such as silence, are effective. Only clear communication to the offerer creates a binding contract. Maria, a seller, receives an offer from Tom and responds by changing the closing date before signing and returning the document. What is the legal effect of Maria's response? Is it A. It creates a binding contract? B. It is considered an acceptance? C. It constitutes a counteroffer? Or D. It has no legal effect? The correct answer is C. It constitutes a counteroffer. Maria's change to the closing date is a counteroffer, not an acceptance. A counteroffer rejects the original offer and proposes new terms, requiring Tom's acceptance to form a contract. A buyer submits an offer to purchase a property, but the seller waits 5 days before accepting and notifying the buyer. If the offer stated it would expire in 3 days, what is the status of the contract? Is it A, a valid contract exists? C, the seller can enforce the contract? Or D, no contract exists? The correct answer is D, no contract exists. Because the seller accepted after the offer expired, there is no contract. Offers must be accepted within the time frame stated, or they lapse and cannot be accepted later. Contract validity and voidable terms. Which of the following is required for a contract to be considered valid in a real estate transaction? Is it A, all parties must be legally competent? B, the contract must be in writing only if the parties agree? C, the contract must be witnessed by a notary? Or D, the contract must be recorded with the county? The correct answer is A, all parties must be legally competent. A valid contract in real estate requires mutual consent, lawful objective, competent parties, and consideration. Without these elements, the contract may be void or unenforceable, according to most state licensing authorities. Which statement about voidable contracts in real estate is not correct? Is it A, a voidable contract is valid until rescinded by the injured party? B, a contract signed under duress may be voidable? C, either party may void a voidable contract at any time? Or D, a minor entering a contract may make it voidable? The correct answer is C. Either party may void a voidable contract at any time. Why this may be tricky. The term voidable means the contract is valid unless rescinded by the wronged party. Only the party harmed by the defect can void it, not both parties or a third party. Maria, a seller, discovers after signing a purchase agreement that the buyer misrepresented their identity. What is the status of the contract? Is it A, the contract is automatically void? B, the contract is voidable by Maria? C, the contract remains fully enforceable by both parties? Or D, the contract must be renegotiated? The correct answer is B, the contract is voidable by Maria. A contract based on fraud or misrepresentation is typically voidable at the option of the party harmed, in this case, Maria. She may choose to rescind the agreement due to the buyer's misrepresentation. A buyer and seller sign a contract for the sale of a home, but the contract lacks a legal description of the property. What is the likely legal status of this contract? Is it A, the contract is voidable by the buyer only? B, the contract is valid but unenforceable in court? C, the contract is valid if both parties agree to proceed? Or D, the contract is void? The correct answer is D, the contract is void. A contract missing an essential element, such as a legal description of the property, is generally considered void because it lacks certainty and cannot be enforced by law. Contingencies and amendments definitions. What is the primary purpose of a contingency clause in a real estate contract? Is it A, to make the contract dependent on certain events occurring? B, to guarantee the sale will close on the original date? C, to allow the agent to change the commission rate? Or D, to remove the need for earnest money? The correct answer is A, to make the contract dependent on certain events occurring. A contingency clause allows one or both parties to back out or modify the contract if specific conditions are not met, protecting their interests until those conditions are satisfied. Which of the following statements about amendments and addenda in real estate contracts is not accurate? Is it A, an amendment modifies the terms of an existing contract? B, an addendum adds additional terms to the contract without altering existing ones. C. An amendment adds new terms to the contract without changing existing ones. Or D. An addendum is attached to the contract at the time of signing or later as needed. The correct answer is C. An amendment adds new terms to the contract without changing existing ones. Why this is tricky. The terms amendment and addendum are often confused. Amendments change existing contract terms, while addenda add new terms. The incorrect statement is the one that reverses their definitions. Maria, a buyer, submits an offer on a home with a financing contingency, and the seller accepts. If Maria's loan is denied, what is the likely outcome according to standard contract practices? Is it A. Maria must purchase the home using other funds? B. The contract is terminated without penalty to Maria? The seller can force Maria to close regardless of financing. Or D. Maria automatically forfeits her earnest money deposit. The correct answer is B. The contract is terminated without penalty to Maria. If a financing contingency is included and the buyer's loan is denied, the contract is typically terminated and the buyer is not obligated to proceed, protecting the buyer from loss. Real estate finance. Which type of mortgage allows the borrower to make only interest payments for a set period before principal payments begin? Is it A. Interest-only mortgage, B. Adjustable rate mortgage, balloon mortgage, or D. Reverse mortgage? The correct answer is A. Interest-only mortgage. An interest-only mortgage lets the borrower pay just the interest for a certain period, after which they must start paying both principal and interest. This can result in lower initial payments but higher payments later. Which of the following is not a feature of a fixed-rate mortgage? Okay, is it A. The interest rate remains the same for the life of the loan? B. Monthly principal and interest payments do not change due to rate adjustments? The loan term can change based on market conditions? Or D. The loan is typically amortized over a set period, such as 30 years? The correct answer is C. The loan term can change based on market conditions. Why this can be tricky? The term fixed rate refers to the interest rate, not the payment amount or loan term. Some may confuse fixed payments with fixed rates, but only the interest rate is guaranteed to remain the same. Maria is considering a loan where the interest rate may increase or decrease over time based on a financial index. What type of mortgage is she most likely reviewing? Is it A. Fixed rate mortgage, B. Adjustable rate mortgage, C. Graduated payment mortgage, or D. Reverse mortgage? The correct answer is B. Adjustable rate mortgage. Maria is looking at an adjustable rate mortgage, which features an interest rate that can change periodically according to a specific index, affecting her future payments. Which statement about a balloon mortgage is least accurate? Is it A. It typically has lower monthly payments than a fully amortizing loan? B. A large payment is due at the end of the loan term? C. It may be attractive to borrowers planning to sell or refinance before the balloon payment is due? Or D. The loan balance is always fully paid off by the end of the scheduled monthly payments? The correct answer is D. The loan balance is always fully paid off by the end of the scheduled monthly payments. Why this may be tricky? Balloon mortgages can have lower payments during the term, but the key feature is the large final payment. Some may confuse this with fully amortizing loans, but balloon loans do not pay off the entire balance through regular payments. A lender offers Sam a loan where he receives monthly payments from the lender instead of making payments, and the loan is repaid when he sells the home or passes away. What type of mortgage is this? Is it A. Interest-only mortgage, B. Balloon mortgage, C. Reverse mortgage, or D. Adjustable rate mortgage. The correct answer is C. Reverse mortgage. This describes a reverse mortgage, which is designed for older homeowners to convert home equity into cash, with repayment deferred until the home is sold or the borrower dies. Interest rate structures and loan features definitions. Which type of loan features an interest rate that remains the same for the entire repayment period? Is it A. Fixed rate loan, B. Adjustable rate loan, C. Graduated payment loan, or D. Balloon loan? The correct answer is A. Fixed rate loan. A fixed rate loan has an interest rate that does not change throughout the life of the loan, providing predictable payments for the borrower. Which loan feature is least likely to protect a borrower from rising interest rates over time? Is it A. Interest rate cap, B. Fixed rate period, C. Fully adjustable rate structure, or D. Conversion option? The correct answer is C. Fully adjustable rate structure. Why this can be tricky? The question asks for the feature that offers the least protection, not the most. Adjustable rate loans expose borrowers to rate increases, while other options offer some form of protection or predictability. Maria is considering a mortgage where her monthly payments will increase at set intervals even if interest rates do not change. What type of loan is she most likely reviewing? Is it A. Interest-only loan, B. Graduated payment mortgage, C. Reverse mortgage, or D. Adjustable rate mortgage? The correct answer is B. Graduated payment mortgage. A graduated payment mortgage has scheduled increases in payments, regardless of interest rate changes, often to accommodate expected income growth. Amortization and loan term concepts. What is the primary purpose of amortization in a real estate loan? Is it A. to ensure the loan is paid off in full by the end of the term, B. to reduce the interest rate on the loan, C. to increase the loan balance over time, or D. to allow for interest-only payments indefinitely? The correct answer is A. to ensure the loan is paid off in full by the end of the term. Amortization is used to gradually pay off both the principal and interest of a loan over a set period, resulting in full repayment by the end of the term. Which of the following statements about loan terms is not accurate for a typical fixed-rate mortgage? Is it A. Monthly payments remain the same throughout the loan term, B. The interest rate is set at the beginning and does not change, C. The interest rate may increase or decrease during the loan term, or D. The loan is typically repaid in equal installments over the term? The correct answer is C. The interest rate may increase or decrease during the loan term. Why this can be tricky? The distractors are plausible, but only one statement is clearly false for fixed-rate mortgages, which do not have changing interest rates during the term. Maria takes out a 30-year mortgage with monthly payments that include both principal and interest. After 15 years, what will have happened to the principal balance compared to the original amount? Is it A. It will be higher than the original amount, B. It will be lower than the original amount, it will be the same as the original amount, or D. It will be completely paid off? The correct answer is B. It will be lower than the original amount. Over 15 years of an amortizing loan, Maria will have paid down a significant portion of the principal, so the balance will be lower than the original amount. Government loan programs terminology. Which government agency insures loans made by approved lenders for single-family homes under the FHA program? Is it A. Department of Veterans Affairs, B. Federal National Mortgage Association, C. Federal Housing Administration, or D. Government National Mortgage Association? The correct answer is C. Federal Housing Administration. The Federal Housing Administration, or FHA, is the government agency that insures loans made by approved lenders for single-family homes. This insurance protects lenders against losses if borrowers default on their mortgages. Which of the following is not a typical feature of a VA guaranteed loan? Is it A, no down payment required? B, private mortgage insurance is required? C, loans are guaranteed by the Department of Veterans Affairs? Or D, the borrower must be an eligible veteran or service member? The correct answer is B, private mortgage insurance is required. Why this can be tricky. Many assume all government loans require a down payment, but VA loans often allow zero down payment. The key is recognizing that private mortgage insurance is not required for VA loans, which sets them apart from other programs. Maria is purchasing her first home, and her lender suggests a USDA rural development loan. What is the main eligibility requirement for this government loan program in Maria's situation? Is it the property must be located in a designated rural area? B, the borrower must be a first-time homebuyer? C, the borrower must be a veteran? Or D, the property must be a multifamily dwelling? The correct answer is A, the property must be located in a designated rural area. USDA rural development loans are primarily intended for borrowers purchasing homes in designated rural areas and who meet specific income limits, making rural location the main eligibility factor in Maria's case. Foreclosure and default process terms. What is the primary purpose of a deficiency judgment in the foreclosure process? Is it A, to recover the remaining loan balance after a foreclosure sale? B, to transfer property ownership to the lender? C, to prevent the borrower from declaring bankruptcy? Or D, to release the borrower from all mortgage obligations? The correct answer is A, to recover the remaining loan balance after a foreclosure sale. A deficiency judgment allows the lender to pursue the borrower for any remaining balance owed after the foreclosure sale if the sale proceeds do not cover the full debt. This is a key term in foreclosure law. Which of the following is not typically a result of a borrower's default on a mortgage loan? Is it A, acceleration of the loan balance? B, foreclosure proceedings may begin? C, increase in property taxes? Or D, negative impact on the borrower's credit score? The correct answer is C, increase in property taxes. Why this can be tricky. All options may seem related to default, but only one is not a direct result. Acceleration of the loan, foreclosure proceedings, and damage to credit are direct consequences, while an increase in property taxes is not caused by default. After missing several mortgage payments, Maria receives a notice of default from her lender. What does this notice generally signify in the foreclosure process? Is it A, the property has already been sold at auction? B, the lender is formally notifying Maria that she is in default and foreclosure may proceed? C, Maria's mortgage has been automatically reinstated? Or D, the lender has forgiven Maria's missed payments? The correct answer is B. The lender is formally notifying Maria that she is in default and foreclosure may proceed. A notice of default is a formal document sent by the lender to inform the borrower that they are in default and that foreclosure proceedings may begin if the default is not cured within a specified time.
Did you get a different answer? Or maybe you have a question about the exam in general? Drop it in the comments below. We read and answer them personally.
Property, valuation, and appraisal. Which principle of value states that the value of the property is influenced by the cost to acquire a similar substitute property with equal utility and desirability? Is it A, principle of conformity? B, Principle of substitution. C. Principle of anticipation. Or D. Principle of progression. The correct answer is B. Principle of substitution. The principle of substitution holds that a property's value is set by the cost of acquiring an equally desirable substitute. This is a foundational concept in property valuation and underpins most appraisal methods. Which of the following is not considered a type of value commonly used in real estate appraisal? Is it A. Market value, B. Assessed value, C. Market rent value, or D. Investment value? The correct answer is C. Market rent value. Why this can be tricky? All the options sound plausible, but market rent value is not a standard value type. Appraisers typically refer to market value, assessed value, and investment value, but not market rent value. If an appraiser states that a property's value is based solely on its original purchase price, which appraisal principle is being incorrectly applied? Is it A. Principle of substitution, B. Principle of conformity, C. Principle of contribution, or D. Principle of anticipation? The correct answer is A. Principle of substitution. Why this is tricky? The purchase price is not always equal to current market value. The principle of substitution, not cost, determines value in most cases. Relying on original price ignores market changes and other valuation principles. Maria is appraising a home in a neighborhood where most properties are well maintained, but the subject property is in poor condition. Which appraisal principle explains why the subject property's value may be higher than similar homes in less desirable areas? Is it A. Principle of regression, B. Principle of substitution, C. Principle of progression, or D. Principle of anticipation? The correct answer is C. Principle of progression. The principle of progression states that a lower quality property can be positively affected by being among higher quality properties, raising its value above similar properties in less desirable locations. Approaches to value terminology. Which approach to value is most commonly used to appraise single-family residential properties? Is it A. Sales comparison approach, B. Cost approach, income approach, or D. Gross rent multiplier approach? The correct answer is A. Sales comparison approach. The sales comparison approach is most commonly used for single-family residential properties because it relies on comparing similar properties that have recently sold, which provides a reliable estimate of market value. Which term best describes the process of estimating the current cost to construct a replica of a building using modern materials and standards, regardless of outdated features? Is it A. Reproduction cost, B. Depreciated value, C. Replacement cost, or D. Market value? The correct answer is C. Replacement cost. Why this can be tricky? The term replacement cost refers to constructing a building with modern materials and standards, not duplicating obsolete features. Reproduction cost means an exact copy, which is a common confusion point. An appraiser is valuing a small retail building by analyzing its net operating income and applying a capitalization rate derived from similar properties in the area. Which approach to value is the appraiser using in this situation? Is it A. Cost approach, B. Income approach, C. Sales comparison approach, or D. Gross rent multiplier approach? The correct answer is B. Income approach. The income approach is used when an appraiser values a property based on its ability to generate income, which is common for commercial properties like retail buildings. Market value and price distinctions. Which term describes the most probable price a property should bring in a competitive and open market under all conditions requisite to a fair sale? Is it A, assessed value, B, market price, C, market value, or D, book value? The correct answer is C, market value. Market value is defined as the most probable price a property should bring in a competitive and open market, assuming both buyer and seller are acting prudently and knowledgeably, and the sale is not affected by undue stimulus. Which statement about market value and market price is not correct? Is it A, market value is an estimate based on typical market conditions? B, market price always equals market value? C, market price is the amount a buyer actually pays for a property? Or D, market value assumes both parties are well informed and acting without pressure? The correct answer is B, market price always equals market value. Why this can be tricky? Market price is the actual transaction amount, which may be above or below market value depending on circumstances. The other statements accurately describe the relationship between market value and market price. Depreciation types and concepts. Which type of depreciation results from normal wear and tear over time? Is it A, physical deterioration, B, functional obsolescence, C, external obsolescence, or D, economic depreciation? The correct answer is A, physical deterioration. Physical deterioration is the loss in value due to normal wear and tear from regular use or exposure to the elements. It is one of the three main types of depreciation recognized in property valuation. Which of the following is least likely to be curable when appraising a property for depreciation purposes? Is it A, peeling paint on exterior walls, B, outdated kitchen appliances, a nearby landfill causing unpleasant odors, or D, worn carpeting in the living room? The correct answer is C, a nearby landfill causing unpleasant odors. Why this is tricky? The term curable can mislead test takers. External obsolescence is almost always considered incurable because it results from factors outside the property owner's control, unlike many forms of physical or functional depreciation. A property owner discovers that a new highway has been built nearby, causing a significant drop in property value. What type of depreciation is this considered under appraisal concepts? Is it A, physical deterioration, B, external obsolescence, C, functional obsolescence, or D, economic depreciation? The correct answer is B, external obsolescence. This situation describes external obsolescence, which is a loss in value due to outside influences such as new infrastructure or environmental changes that negatively affect the property. Real estate practice and disclosures. Which document is typically used to disclose the presence of lead-based paint in residential properties built before a certain year? Is it A, natural hazard disclosure statement, B, transfer disclosure statement, C, lead-based paint disclosure form, or D, seller property questionnaire? The correct answer is C, lead-based paint disclosure form. Federal law requires the use of a lead-based paint disclosure form for most residential properties built before 1978. This form informs buyers or tenants of any known lead-based paint hazards. Which of the following is not typically required to be disclosed by a seller in a standard residential real estate transaction? Is it A, known structural defects, B, seller's reason for moving, C, presence of hazardous materials, or D, past flooding issues? The correct answer is B, seller's reason for moving. Why this can be tricky? All options seem important, but only material facts and known hazards must be disclosed. The seller's reason for moving is generally not a required disclosure unless it affects the property's value or desirability. If a real estate agent is aware of a material defect that the seller has not disclosed, what is the agent's obligation? Disclose the defect to the buyer. B. Only inform the seller's attorney. C. Remain silent unless asked directly by the buyer. Or D. Wait until escrow closes to disclose the defect. The correct answer is A. Disclose the defect to the buyer. Why this is tricky. Some may think the agent can remain silent, but agents are legally required to disclose all known material facts to buyers, even if the seller does not. Maria is selling her home and knows the roof leaks during heavy rain, but does not mention it on the disclosure forms. What is her legal responsibility regarding this information? Is it A. She is only required to disclose if the buyer asks directly? B. She can wait until after the sale to disclose the issue? C. She must disclose the leaking roof on the required forms? Or D. She can avoid disclosure if the defect is not visible during showings? The correct answer is C. She must disclose the leaking roof on the required forms. Sellers are legally required to disclose known material defects, such as a leaking roof, to potential buyers. Failing to do so can result in legal liability for non-disclosure. A buyer receives a transfer disclosure statement that omits information about a recent plumbing repair. After moving in, the buyer discovers ongoing plumbing issues. What recourse does the buyer have based on disclosure laws? Is it A. None, because the seller attempted repairs before the sale? B. The buyer may pursue legal action for non-disclosure? C. The buyer must pay for all repairs regardless of disclosure? Or D. The agent is solely responsible for the omission? The correct answer is B. The buyer may pursue legal action for non-disclosure. Buyers may have legal recourse if a seller fails to disclose known material defects, such as ongoing plumbing problems, even if repairs were attempted but not fully resolved. Fair housing laws and protected classes definitions. Which of the following is considered a protected class under the Federal Fair Housing Act? Is it A. Age, B. Occupation, C. National origin, or D. Credit score? The correct answer is C. National origin. Race, color, religion, sex, national origin, familial status, and disability are protected classes under the Federal Fair Housing Act. These categories are specifically named in the law to prevent discrimination in housing. Which of the following is not a protected class under federal fair housing laws? Is it A. Disability, B. Marital status, C. Familial status, or D. Religion? The correct answer is B. Marital status. Why this is tricky. The question uses a negative, asking for what is not protected. Marital status is not a protected class under federal law, though it may be protected under some state laws. The other options are federally protected. A landlord refuses to rent to a family with children, claiming the building is adults only. Is this allowed under federal fair housing laws? Is it A. Yes, landlords can set any occupancy rule. B. Yes, if the building has fewer than 4 units. C. Yes, if the lease says so. Or D. No, this is discrimination based on familial status. The correct answer is D. No, this is discrimination based on familial status. Why this can be tricky. Some may think landlords can set age limits, but refusing families with children is discrimination based on familial status, which is prohibited unless the property qualifies as senior housing. Maria, a real estate agent, tells a client that a certain neighborhood is not suitable for families with children because most residents are older adults. Does this statement violate fair housing laws? Is it A? Yes, it is illegal steering based on familial status. B. No, it is just providing information. C. No, if the client asked for this information. Or D. Yes, but only if the client complains. The correct answer is A. Yes, it is illegal steering based on familial status. This statement violates fair housing laws because it discourages families with children, a protected class, from considering housing in that area, which is considered discriminatory steering. A property manager denies an application from a person with a service animal, stating that the building has a strict no pets policy. Is this action compliant with fair housing laws? Is it A? Yes, because service animals are considered pets. B. Yes, if the policy is in writing. C. No, because reasonable accommodation for disabilities is required. Or D. No, unless the animal is not certified. The correct answer is C. No, because reasonable accommodation for disabilities is required. Denying a person with a service animal is not compliant with fair housing laws, as disability is a protected class, and reasonable accommodations must be made for service animals. Advertising and misrepresentation terms. Which of the following best describes the legal definition of misrepresentation in real estate advertising? Is it A, a false or misleading statement made about a property, regardless of intent? B, an opinion about a property's value? C, a typographical error in an advertisement? Or D, a statement made only by the property owner? The correct answer is A, a false or misleading statement made about a property, regardless of intent. Misrepresentation in real estate advertising occurs when a licensee provides false or misleading information about a property or transaction, whether intentionally or unintentionally, that could influence a consumer's decision. Which statement about advertising a property as sold is most accurate under real estate regulations? Is it A, a property can be advertised as sold once an offer is accepted? B, a property can be advertised as sold after the inspection is completed? C, a property can be advertised as sold only after the transaction closes? Or D, a property can be advertised as sold at any time with the seller's permission? The correct answer is C, a property can be advertised as sold only after the transaction closes. Why this can be tricky. Advertising a property as sold before the transaction closes is misleading, even if a contract is signed. Only after the sale is finalized can it be advertised as sold, to avoid misrepresentation. Maria, a licensed agent, posts an online ad stating a home has the best view in the city, but several nearby homes have similar views. Is this considered misrepresentation under real estate advertising rules? Is it A, yes, because any exaggeration is illegal? B, no, because this is considered puffing and not a factual claim? C, yes, because other homes have similar views? Or D, no, because online ads are not regulated? The correct answer is B, no, because this is considered puffing and not a factual claim. This is considered puffing, which is an exaggerated opinion rather than a factual misrepresentation, so it is generally not a violation unless it is proven to be intentionally deceptive. Licensee, responsibilities, and violations terminology. Which term describes a licensee's failure to disclose a material fact to a buyer during a real estate transaction? Is it A, non-disclosure? B, commingling? C, conversion? Or D, dual agency? The correct answer is A, non-disclosure. Omitting a material fact that could influence a buyer's decision is called non-disclosure, which is a violation of licensee responsibilities. Licensees are required to disclose all known material facts to all parties in a transaction. Which of the following is not considered a violation of a real estate licensee's fiduciary duties? B. Misusing client funds. C. Acting in the client's best interest. Or D. Withholding material information from a client. The correct answer is C. Acting in the client's best interest. Why this can be tricky? The correct answer is acting in the client's best interest, which is actually fulfilling a fiduciary duty. The other options all describe actions that violate a licensee's fiduciary responsibilities. During a property showing, Agent Maria tells her buyer client that the roof was replaced last year based on the seller's statement, but she never verified this information herself. If the roof was not actually replaced, what type of violation could Maria be committing? Is it A. Commingling, B. Misrepresentation, C. Undue influence, or D. Puffing? The correct answer is B. Misrepresentation. Maria may be committing misrepresentation by passing along unverified information as fact. Licensees must take reasonable steps to verify material information before communicating it to clients. Property management. Which type of lease automatically renews for another term unless proper notice is given to terminate? Is it A. Estate for years, B. Periodic tenancy, C. Tenancy at sufferance, or D. Gross lease? The correct answer is B. Periodic tenancy. A periodic tenancy lease automatically renews for another period unless either party gives notice to terminate. This is a common arrangement for month-to-month rentals and is defined by the regular recurrence of the rental period. Which of the following is not typically the responsibility of the tenant under a net lease? Is it A. Property taxes, B. Insurance premiums, C. Structural repairs, or D. Routine maintenance? The correct answer is C. Structural repairs. Why this can be tricky? Net leases often require tenants to pay for property taxes, insurance, and maintenance, but the landlord usually remains responsible for structural repairs. The distractors are plausible because tenants do pay many costs in net leases. Maria signs a lease that allows her to terminate the agreement at any time with 30 days' notice, while the landlord can only terminate at the end of each year. What type of lease does Maria have? Is it A. Estate for years, B. Periodic tenancy, C. Tenancy at sufferance, or D. Tenancy at will? The correct answer is D. Tenancy at will. This is a tenancy at will, which allows at least one party to terminate the lease at any time with proper notice. The scenario describes flexibility for Maria, which is characteristic of this lease type. A gross lease most commonly requires the landlord to pay which of the following expenses? Is it A. Property taxes, B. Tenant's personal utilities, C. Tenant's business insurance, or D. Tenant's janitorial services? The correct answer is A. Property taxes. Why this is tricky? The term gross lease can be confused with other lease types. In a gross lease, the landlord pays most property expenses, including taxes, insurance, and maintenance, while the tenant pays only rent. Tenant rights and landlord obligations definitions. Which of the following best defines a landlord's obligation to provide a habitable property to tenants? Is it A. The duty to maintain the property in a safe and livable condition, B. The right to collect rent on time, C. The ability to enter the property at any time, or D. The requirement to provide tenant insurance? The correct answer is A. The duty to maintain the property in a safe and livable condition. Landlords are legally required to ensure that rental properties meet basic health and safety standards, such as working plumbing, heating, and structural integrity. This obligation is commonly referred to as the warranty of habitability. Which statement about a tenant's right to privacy is not accurate? Is it A, landlords must generally provide notice before entering a tenant's unit? B, tenants have a right to privacy in their rented home? Landlords may enter without notice for routine inspections. Or D, emergency situations may allow entry without prior notice. The correct answer is C, landlords may enter without notice for routine inspections. Why this is tricky? The question asks for the exception, not the rule. Tenants have a right to privacy, but landlords may enter with proper notice or in emergencies. Entry without notice for routine inspections is not allowed. Maria rents an apartment and reports a broken heater in winter. What is the landlord's legal obligation in this situation? Is it A, ignore the complaint if rent is unpaid? B, repair the heater within a reasonable time to restore habitability? Or D, require Maria to fix the heater herself? The correct answer is B, repair the heater within a reasonable time to restore habitability. The landlord must repair essential services like heating promptly to maintain habitability. Failing to do so could violate tenant rights and local housing codes. A landlord enters a tenant's unit without notice while the tenant is at work, claiming it was to check the smoke detectors. Is this allowed under typical landlord-tenant laws? Is it A, yes, if the landlord owns the building? B, yes, if the tenant has not paid rent? C, yes, if the landlord suspects a fire hazard? Or D, no, because routine checks require advance notice to the tenant? The correct answer is D, no, because routine checks require advance notice to the tenant. Landlords generally must provide advance notice before entering a tenant's unit for non-emergency reasons. Entering without notice for routine checks violates most tenant privacy laws. Eviction process and notice terms. What is typically required before a landlord can begin the formal eviction process for non-payment of rent? Is it A, a written notice to pay or quit? B, immediate removal by law enforcement? C, a verbal warning only? Or D, filing a police report? The correct answer is A, a written notice to pay or quit. Most jurisdictions require landlords to provide tenants with a written notice, often called a pay or quit notice, before starting formal eviction proceedings for non-payment of rent. This notice gives the tenant a chance to pay the overdue rent or vacate the property. Which of the following statements about notice periods in the eviction process is always true? Is it A, all eviction notices require a 30-day period? B, notice periods for eviction can differ based on the reason for eviction? C, tenants never have the right to cure the violation after notice is given? Or D, a landlord can skip the notice period if the tenant is late on rent? The correct answer is B. Notice periods for eviction can differ based on the reason for eviction. Why this is tricky? Notice periods can vary by jurisdiction and by the reason for eviction. There is no single rule that applies to all situations, so statements using absolutes like always are often incorrect. Maria, a property manager, discovers that a tenant has violated the lease by keeping a pet in a no-pet building and wants to start the eviction process. What is the first step she should take according to standard notice procedures? Is it A, change the locks on the tenant's apartment? B, file an eviction lawsuit immediately? C, serve a written notice to cure or quit? Or D, call animal control to remove the pet? The correct answer is C, serve a written notice to cure or quit. Maria must provide the tenant with a written notice specifying the lease violation and giving the tenant an opportunity to correct the issue or vacate. This is a required first step before any formal eviction action can proceed.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit birdsey.ai to start your free trial of Birdsey, your AI-powered study partner.